Okay, great.
Okay. As you know, my name is DeWitt Sylvester Stallworth. I work for the Scanlon County Area Transit. I had my little statement wrote down. I would like to say for the record, Miss Ellis, Mr. Hall, Mr. Kimbrough, my buddy Mark McElmore, Mr. Meadow, Mr. Marina, and Miss Hugh, the attorney, and Miss Kristen, this young lady, Miss Nikki. Would like to say for the record, the clerk of the court, Pam Childers, and I was at the open forum, Pam Childers, was completely out of order with the comments about 3.5 years of negotiation she's been involved. For one, she's been to one negotiation, Mr. Marina, but she said she had been involved. She was there and it was appalling. She was appalled the way this team was conducting themselves, you know. Being involved for one negotiation section, Mr. Marina, Mr. Attorney, Miss Hill, I think that's your last. You have to put it on there. Hill, Miss Kristen, I'm gonna say Miss Kristen. As a spectator to speak as a representative on behalf of the county for your negotiation team, speaking volumes about these processes. This union team has provided proposals on every article, sometimes numerous proposals. Most of the union proposals are ignored and they never ever discuss the facts truly do matter. So I don't know why she would say that, you know, but she's been in one negotiation. But she said it's appalling. How can she say it's appalling? She just been to one negotiation. You know, and these people where I work are suffering. What's suffering? You know, and there's a whole lot of things I can say about it. You know, there's a lot of people come up with a lot of things, say a lot of things to me, and I'm gonna say one thing. Like they said, the place is 75% black, and from my understanding, from what I'm hearing from my union members is that if this place was lily white, it wouldn't be no problem. This negotiation would have been over. But simply because it's 75% black, we having all these problems. Well, we shouldn't have no problem with this negotiation should have been over. Should have been over. Mr. Marino, Miss Ellis, Mr. Attorney. So that's all I have to say.
Okay.
Thank you for listening.
Appreciate your comments.
Thank you.
I will say that I strongly disagree with that last statement.
Well, I disagree with what Miss.
And you can disagree with
Correct.
what Ms. Childers says.
That's right.
Ms. Childers is an honorable elected official, and she has the opportunity and the wherewithal to speak what she feels like she
Yes,
needs to
sir.
speak for the dais and represent herself.
Yes, sir. I understand what you're saying, and because I voted for her, because I thought Ernestine McGahey had run his course. Me and four of my siblings voted for her.
Okay.
But when she come up for a re-election, I would not vote for her, and I would do everything I can, because it's my right
That's certainly your prerogative.
to campaign against her, to keep up, you know.
Well, let's move this forward. Let's see if we can get started.
Thank you.
And let's see if we can make
Y'all
some
have a
progress.
great day, Mike. Jim. Elaine. My sister Elaine Wiggins.
All right.
Wonderful person. Have a good-
So before we get started, we want to go around the room and introduce ourselves for the record.
See you later.
And Mr. Administrator, we can get signing.
We got to go in.
Always a couple.
For the record, Mike, we haven't been receiving the sign-in sheets, but after the comments that Ms. Childers said this morning, I'd like a copy of all the sign-in sheets. If you don't mind. Thank you.
Thank you,
I
sir.
appreciate it.
Oh, Nikki Powell, Clerk of Court. Crystal Ladura, County HR.
Kristen Hewell, County Attorney's Office.
West Marino County Administration.
Mike Battlemore.
Wesley Hall County Administration.
Tom Hills, ECAT.
Rodriguez Kimbrough, EGAT.
Curtis Howard, ATU International.
Mike Lowry, ATU Local 1395.
Jim Stanton, ATL, Local 1395.
Elaine Wiggins, ECAT, Financial State Secretary, ATU 1395.
And my daughter, Lisa Marie.
Lisa Marie.
Lisa Marie Lowry.
All right.
You know, I was once, one time when my daughter was about her age, it was take your child to work. And so I took my daughter to work.
Yeah.
And I was bargaining at the state of Florida. She was sitting quietly in the room, watching us bargain. And after about an hour, she said, I can't take this anymore. I'm gonna call my mother to go home. So boring.
My kids have grown up going to union meetings and negotiations. The only thing she said on the way here is the internet gonna work?
Well, what we have done, what the team has done, is identify a couple of articles, several really, and we think that we're close on these articles so that we might be able to reach some agreement. And if you're willing and open, I can go through these, or if you have something else that you'd like to start with, you're welcome to do that.
We will, I got you, Mike. We will, listen to you, and then after that, we will, also be requesting that you give us something, or we guys will do that, but we'd like to start off with making any progress we can.
Okay, great. So let's start in this, I'm just gonna go through numerical order, not any order of priority. And I think the first is Article 1. And I think the only issue we have with Article 1 is union dues. And I think that the only issue we have with union dues, although Nikki, if there's some kind of process problem with the language, jump in. Because I'm just gonna talk about.
Didn't want to handle
Oh, you want to handle
that.
that?
We could, I mean.
Yeah, sure. Yeah.
Cases are too much.
Just for your sake of reference, we have a copy for the several articles that we're going to talk about this afternoon. We have copies of yours and ours, so you can have quick reference.
Okay.
Hey, Mike?
Yeah.
It's always after the last pay of the month. It's never after the second pay of the month, the last pay of the month.
Okay. So, I think there's two issues with union dues. One is that the language that you have is that we agree to deduct special dues, assessments, and/or fees, and then there's some language that goes into approved and voted assessment, and then it says arbitration of legal fee. Now, if we were to look at the statute, which is 447 Part 2. Just so that we're all on the same page. Well, there you go. Look at that. Kristen is like she's like a mind reader. So the language that you have in your article is not the language that's in the statute. And we just want to line them up. I don't think it changes anything in terms of what you can get. because under the statute, you could get dues and uniform assessments. So, what we're prohibited by law is to collect fines, penalties, or special assessments. So we just want to make sure that we're compliant with the statute. Let me show you what I'm talking about.
So the statute, you can, it says basically that's a minimum of what you have to do, correct?
Yeah, but it's these things you can't do.
The bottom.
So what we were thinking about doing was, saying, we'll deduct, membership dues and assessments in accordance with section 447, 43034 of the statutes, which is whatever is allowed by law. Open up. I think the other issue is a process issue, and that is what Nikki just said. It's deducted from the last paycheck of the month.
It's sent after the last paycheck
It's
of the
sent
month.
after the last paycheck of the month. So if there's a
The third pay. then
If the third pay, or if there's
it's
one
after
pay,
the
or whatever.
last paycheck of the month.
Yeah.
And I think our proposal had addressed that. That- So dues will be provided to the union financial secretary or president as soon as possible with reasonable allowance for processing by the office of the clerk of court. And we didn't specify, it's just, it comes once a month at the end of the month, but that's not, this was requested by you guys.
Right, right. I'm just looking at this one.
Sorry, yeah. So I think our proposal was intended to capture current practice.
Okay.
In the old contract, it was remitted, I think, twice a month.
Well, when they came under the county, we did not remit twice a month because that's not how we process.
Right. So that's the difference between the old contract language is what the union proposed versus what we were proposing.
That's not how you process what?
Remitting the
Any
dues.
payments, any payments that are processed by the clerk of court that are deductions from employees' paychecks, are submitted on the last paycheck of the month, unless it's child support. That's the only thing that goes every payday.
So is it a problem to do it?
Yes, it would require a complete reconfigure of the system.
I think those are the two issues.
And so, just so I understand, Mike, that you just want to do what the statute 402 says you can do, and you want to keep the practice that's currently being done once a month.
Yeah, well, after the last paycheck.
So we understand. We're just taking these in the caucus, but I just want to make sure we go in the caucus, we understand.
Good, good.
And I understand.
Good. Is there any other issue that I'm missing on one? I think everything else is pretty straightforward, definitions, recognition, non-discrimination, all that's good.
Okay.
When you're ready, I'll call the next one.
We're ready.
Okay, all right, now Article 2, which is the probationary period article. And you should have a copy of yours and ours, which would be, I think ours is last dated 4/16/21, and yours is last dated March 2nd, 21. And I think there's 3 issues here, maybe 4, and I think we can resolve all.
Okay.
Let's go to section 1. The issue with section 1 is that we struck the portion of your proposal that said, with written notice to the union, if we extend a probationary period, we're willing to give you that language.
Okay.
In section 2, it allows for language that says that a person under the probationary period has the ability to file a grievance. Both of our language says all rights, benefits, and privileges, including the application of grievances up to but not including arbitration, shall be applicable to probationary employees. We're good. We're identical on that language. We then say, except for matters regarding the probationary employees, you say qualifications, performance evaluations, or dismissal. We suggested that we also add the word discipline, because discipline might be a step short of dismissal. In other words, we might discipline someone instead of dismissing them. Does that make sense? I mean, right now, like right now, if somebody engaged in misconduct and I was being asked, based on your language and our language, that doesn't have discipline in there, if they said, okay, we're going to discipline this person, I'm going to say, well, if we discipline them, they might be able to grieve it. So why don't you just dismiss them? Then they can't grieve it, right? Under your language and our language, dismissal is not grievable. So I think by adding discipline, it gives us a tool short of dismissal.
Understand?
Yeah. So that's, I think, the only issue in 2. Then the last issue is in section 3. There's language in here allowing the union up to 1 hour. It says, your language says, the union will be permitted up to 1 hour during the new employee orientation to address newly hired employees whose job classification falls within the bargaining unit. The union may coordinate scheduling with the human resources director or designate, I think is what we added. But where we were apart on this in our discussion was that we added the language with the employee's consent. And you objected to the language with the employee's consent. You just wanted your language without that addition.
But we just feel like that it should be part of the orientation. We don't pressure people to sign up, but we think that is a part of something that they're coming into the bargaining unit. They should at least hear our presentation. Whether they sign up or not is strictly an individual thing. But
Okay.
just like your policies and procedures, they're coming into work. So later on, we don't need them to come back and say, well, the union never told us, because you wasn't part of the orientation process.
Okay.
That was our whole issue.
All right.
No more.
We can withdraw with the employee's consent.
I really appreciate it.
And I think with that, we are in agreement on Article 2. Like you, although I think the scheduling should be done with the Human Resources Director or the Director's designee. And that might be the ECAT Safety Manager, but it might be someone else.
Yeah, well, at the time, I think the orientations were being done at ECAT before it came over to the county.
Yeah.
So they're done at Human Resources, so we'll talk about it during caucus, but whoever's coordinating and doing the orientations, that's who we should be coordinating.
Okay.
I don't know if that's a big deal with me.
Okay. I didn't think it would be.
Yeah.
I mean, it's scheduling.
Right, it's just communication,
Yeah.
we want to communicate.
So, and I think this is a pretty common, at least in my contracts that I deal with, it's a pretty common practice that the grievance process has all the grievance steps, including arbitration, in one article. So you have a grievance article, and then you go to a whole separate article for arbitration, because arbitration is really what, the last step of the grievance article, right?
That is correct.
So we've merged the grievance article and the arbitration article together. And, Kristen, do you want to go through any issues that we might be a part of in terms of process?
Sure. So I was a little puzzled as to why in your most recent proposal, you suggested the status quo for both Articles 5 and 6. Mr. Lowry, you and I have even discussed that Article 6 simply isn't practical and the process has never been followed. We've never followed the process. We've always waived it. So I wondered if we could perhaps take a look at what the county previously proposed and see if we could come to an agreement on a process that is practical and that can work for both sides.
Yeah, we'll caucus on it, but yeah, I hear you. I understand.
Okay.
And it's not that we don't want to respond, we need to talk about it before we respond.
Sure.
That's all it is.
And what was proposed, and I'm sure you noticed,
Right.
is largely what's included in the other collective bargaining agreements. And that's for the sake of consistency because we have 5 bargaining units to manage. So what was in the old ECAP contract was, I think, intended to
You're referring to
utilize-
the timelines.
Yes, was intended to be utilized for an operation that was managed in-house. And now, of course, it involves multiple departments. But we're still willing to be flexible in terms of the timeline. So we just, want to try and reach an agreement on the process.
Okay, we understand.
So on the next article is Article 20. The first paragraph, first section of your proposal and ours of 6/25/21, and yours of April 16, 2021. Section 1 is identical, and section 3 is pretty identical. The only difference is you say transit workers and we say operators. And we differ.
I think we have to stick with operators. Is that what was decided by risk management? Instead of all transit workers, which would encompass, I suppose, mechanics and, wasn't that? Okay, so, and that's a coverage issue that's through risk management.
So help me to understand what you just said. I'm not sure I understood
The
that.
felonious assault bond covers operators,
Why?
because that's what the felonious assault bond covers.
I understand that part, and I'm saying why. Because mechanics go out on the road as well. They take buses on the road as well. So I'm not used to, and this is, I'm questioning it because I'm not used to it. Felonious assault policies usually cover the bargaining unit that has interaction with the public.
I don't know the answer, other than the risk manager said it covered operators.
We can get some clarification.
Yep.
Right, but I'm just saying to you that the felonious assault, the reason why we wanted to say transit workers is because bus operators are not the only ones that encounter protection or need protection. Mechanics go out there, they relieve and swap buses, they do a bunch of things as well. Those are probably the only two that actually drive the bus out.
Utility fuelers don't have to have CDLs as well, right?
Yeah, but they don't go out on the road,
No, they don't
they
go out.
interact with the public, so that's all.
I understand that, I just want to make sure they don't go out on the road, that's the question, if they would.
Yeah. Anybody that's going out on the road is subject to the same thing an operator is at any given day. You may have somebody that's, it can encounter.
Okay, we'll take 20 up, not cars.
Okay, just for my own edification, so when you say mechanics go out, are they driving fully loaded buses? I mean,
Not necessarily
That's
fully
true.
loaded, but they swap off buses to, if a bus breaks down and my driver's driving the bus, he could possibly swap out a bus. And while he's out there, he's interacting, people in the public will make you part of the process, whether you want to be or not.
trust me.
Right,
yeah.
so that's what I'm
Plenty
saying,
of
so
time.
they have an opportunity to be assaulted as well.
Okay.
That's all we're saying.
And we'll get some clarification from our registrants.
And, now, go ahead, Mark. Right, they could be in an accident or anything, right. The other, you said group health and welfare, so go ahead, we're fine.
Group health we'll take into our caucus,
Okay,
because there's also the issue of
the committee?
committee.
Yes.
Well, it's my understanding, correct me if I'm wrong, in the county's HR policy, each union is allowed to have one representative on the benefits committee. So we couldn't agree to allow at least one for one union per contract, because one representative is already provided for in the county policy for each union.
Right, so that's a county policy, we understand that. And that policy could be altered in the leader without our input. So we wanted that language, and it had previously been in your proposal as well. And we had already agreed on that language being part of the contract. We're not asking for two, we're asking for the one that's in the policy. We're not asking for two positions. It's not the intent of our, but we want to make sure that we're locked in, that we always have one per the CBA, not per the policy.
Okay.
Which
So-
is the same exact thing, and it's been in the county's proposal. It was only removed during the last proposal y'all gave us.
Okay.
So that's, we thought we actually was having a TA or pretty close to a TA, and then we seen that taken away. So y'all will discuss that too, we would appreciate it.
Okay. We think that what we provided for our 34 uniforms is, does the trick. We don't see, I think we picked up some of your language, and what we have is actually more expansive.
I think when we was at the table before, I think the problem we were having was the whole time we've been bargaining that they hadn't had uniforms provided to them, which was, I think that was most of the stick up.
Yeah, we certainly want people well dressed. So, but we think for the purpose of the contract, Article 34 that we proposed covers everything that it needs to cover.
Well,
And sets
we-
that. Chris, go ahead. No, please.
Well, we tried to include all of the terms that address each classification and capture the current practice. What you proposed doesn't address the uniform allowance for customer service associates, and it also doesn't address part-time or trolley operators. Did you intend to exclude them?
No. You said customer service, trolley, and what was the other one?
You have customer service at the end, but all it shows is an initial clothing allowance. And it's my understanding they do currently receive a uniform allowance. And part-time and trolley also receive an initial uniform and a clothing allowance. And I don't believe they were addressed at all in your proposal.
Okay.
So if you intended to exclude them,
I think we were seeing them as operators. And so-
well, the
so-
current practice, they do, it's my understanding, receive a clothing allowance. It's not the same as a full-time operator, but it is a clothing allowance, and they also get a training uniform, is that correct?
Provide a training uniform, but yes,
Our intent was that they were operators. Most of them work 36 hours plus. So we thought they should get the same allowance as full-time plus operators. And the part-time, you know, so.
And the part-time?
Well, the part-timers get a limited amount, but full-timers, the trolley drivers are similar to the full-time plus operators. And right now, they're receiving less in allowance than they should, in our opinion.
But your proposal just listed full-time operators, correct?
Yes, you're right.
Okay.
We understand.
And Tanya, Rod, can you confirm that what's in our proposal is the current practice, because that was the intent? So, customer service representatives allowance is $400 per fiscal year?
yes, ma'am. What's in our proposal, but I understand, yes, ma'am, what's in the proposal is our actual current practice right now.
Okay.
Yes, ma'am, we do currently have a uniform program, in process currently right now.
And part-time and trolley have a uniform allowance of $250.
Yes, ma'am.
Got it.
We understand.
All right, the last one we have for your consideration is Article 47, which is management rights. And what we've done is we have simply proposed the language in the Public Employees Relations Act on management rights, word for word, so we're not overreaching whatsoever. And that's at 447-209.
Right, you've discussed that, you told us that before, Mike, so we understand. President Lowry wants me to make sure that, the only concern we had was about any policies that the county would make, they would have a discussion with. So that would be section 2 of ours where it talks about having a discussion with the union before the effective date. So that was our issue, not your language on section 1.
We'll talk about that in caucus.
We agree to TA your section 1 is it's never been our problem.
Okay. So that's what we have, I think, that's identifying
Okay, so.
6 articles that are very close.
Yes, and I think we're closer than both sides believe, so yes, we will vote for a caucus on that, but can you give us some insight on the last wage counter proposal that we have provided to you guys?
Yeah, who wants to do that?
Let's talk about it, Tom.
All right.
Okay. All right, so is it all right if we keep this room and we just stop the recording?
Yeah.
We don't have no office in the building.
So,
Yeah.
how do I get, do you want me to just be able to call Mr. Kimber or Tanya or somebody and say we're ready? Yep. Will that work? Okay.
The red button, yes, ma'am.
Stop.
Nah, you are, no
I
way.
verified it was
There you
not
go.
before we-
Nah, it is.
Just breaking that ice, that's all.
We wouldn't want to listen to it anyway.
No, that's the other recording up there.
Trust me, you'll probably find some humor in the stuff we talk about. So, on number one, we just want a clarification, but we think we're there, but we want to make sure that the clarification is so Mike, can you clarify?
Under the statute language, Mike, where it says uniform dues and then uniform assessments. Okay, so let's see if I'm on the same page. Uniform assessments would be, for instance, if hopefully it would
And he
not.
said him, but we talked to our attorney.
Right, so,
Which you know very well.
yeah. So
All right.
would be, for instance, arbitration would be a uniform assessment. For, if we had to go to arbitration and assess the membership, that's what a uniform assessment is.
Yeah, I think a uniform assessment, if you're asking me what I think it is.
Yeah. And
And then
recording.
you're gonna tell us what your lawyers are. I think a uniform assessment is when you assess everyone,
Right,
as opposed to a special assessment, is you assess one person.
okay. So that then leads me into the problem that we have, the only problem that we see in this language, which is our concern about code, ATU code, which has been scratched through.
And that is on an individual basis because people have to sign up for it individually. And it could be an across-the-board assessment as well, but it's not the same.
It's a voluntary contribution, which is not an assessment. An assessment's imposed.
So it wouldn't be illegal.
No, it's not illegal,
No, it's
but
not.
it's also at the county's discretion whether to deduct something of that nature.
So, and currently, you're saying no
Well,
code.
when we say county discretion, can I ask a question? What does that mean?
That means that
But the code-
under the statute, the county is required to deduct uniform dues assessments. A voluntary contribution, however, is discretionary. And I don't know if the clerk's office currently makes deductions
They
for
do.
voluntary contributions.
So we're currently taking code.
Okay.
Well, we can restore that language.
No, that's, if you restore that language, that's the only issue we have.
Okay.
So we can.
We're okay with the timeframe, right? That you're currently
Yes.
utilizing
Yeah,
with providing.
So the current practice is everything we're okay with, the once a month assessment and everything. That is all.
Got it?
So we have a TA on
Okay.
it. Probationary employees, article number 2, we have a TA on that,
Okay.
as discussed. The article 5 and 6, we're okay with the merger that Christian talked about. We want to go back through the grievance process. We'll have some tomorrow as a small counter, and here's why, Mike.
Okay.
The way you proposed it, it lengthens the grievance process, and we're concerned about that, but we want to read through it, because there's some oral stuff and stuff. So we just want to walk through it.
Sure.
It would have took too much time today just to
Yeah,
walk through it.
it's pretty, there's a lot of language.
Right, and so the time, you can say it, but the timeframe is more concerning to us because right now it's really like a 20-day turnaround.
Okay.
Which yours added like an additional 20, 25 days.
Okay.
So, go ahead, Mike.
And the other thing is some of the language emphasizes may, using the word may, have a meeting. Or in one paragraph, it doesn't even, it almost implies that you'll just respond we'll submit the grievance and we'll get a response. We think that's not a productive grievance process. We believe that grievances should be in person and meet and have discussions so you can hear our reasoning, and vice versa. We can hear your reasoning so that we can work things out.
We'll try to present language that's counter tomorrow, but something we think is reasonable enough for you to agree with.
Okay.
And we'll have that first thing in the morning. And then uniforms, we have a few things we want to suggest. So I want to walk through page by page, starting on 57, if you don't mind.
Okay.
On Article 34, page 57, looking at your document.
Yeah.
Section 4, the first sentence, we would like to have that language restored. The only thing it is the company will have their logo, of course, and if you're a union member, that you would have your logo, the union logo on your sleeve. It's an option, we understand that, but that's been there for years. We would like to represent our organization well. So that's number 4. Going over to page 59. Section 5, the last 2 paragraphs before section 6. We want to talk about any deviation or violation. We had some discussions on this before, Mike, basically talking about going to the package store and things of that nature. Is this on the clock? In other words, if I'm driving and I go to the bathroom and I go into a facility, a liquor store or something, are you saying we can't do this on the clock, or are you saying that this is something off duty as well?
Wait, I'm sorry, what section are you on?
I'm on page 59. It's right before section 6, where it says any deviation or violation of uniform standards.
Okay.
That was
and-
status quo language.
And then I think you're looking down at employees may not enter into an establishment whose primary function is to sell alcohol
Yes,
beverages.
yes, so we just wanted to clarify that.
But that's that sentence. And ask your question.
The question was this: are you referring to being on the clock or off duty?
It's probably both, huh?
So,
Yeah,
so you have trolley drivers that go out to the beach, and some of the locations, the cleanest bathrooms, are facilities that serve liquor, that the operators have to go in and use the restroom.
Places whose primary function.
Is it their primary function to
Well, it
serve?
depends on
So-
what primary means.
So I take it
Yeah,
as a
because
package
like-
store, but here it's a tourist, right? The trolley is up and down the beach, so it could be that one of the taverns, their primary thing is a bar,
Right.
right? So we would consider that their primary thing is you going in there for drinks. Of course, they serve food and stuff like that, but their primary business is alcohol. Right? So that's why we want to have some conversation and dialogue.
Yeah.
We don't want an operator coming out, somebody calling in and talking about, this daggone driver went into the daggone tavern and the whole purpose was to go to the bathroom. They didn't come out with a drink in their hand and they're not driving drunk and things of that nature. But we just don't want anybody harmed. That's the whole intent. Just to clarify what it would be.
So that was in your proposal as well, and it's status quo
Wait,
language.
We're just conversating about what the intent would be and how it would be applied. We're not
So,
saying
okay.
that we're opposed to it.
I would say, you want to know where to draw the line. huh?
Right, that's all. That's all. We want to make sure that both sides are saying the same thing, that's all.
Well, I would say like a restaurant that has a bar is not, would not count. I think you have to be a bar. You know, you have to be the Kit Kat Club.
Nice way to put it.
Bamboo Willie.
All right,
So, can I say it? So, Elaine brought up that some of the trolley operators stop at, go ahead, Elaine.
No, I was just saying, it have been an incident where a driver did at the boardwalk on the beach, drive the beach trolley, had to go to the bathroom, but the bathroom was full where he went, so he went to, Babu Wedding to use the restroom.
And
He
that's-
came
that's
right
not a
on
restaurant.
out.
That's not a
It's
restaurant.
affiliated with Hooters, but it's a bar. It is a bar.
Oh, well.
He came right on out.
Yeah,
Just trying to see if we all have common sense.
If we got common sense.
Bamboo Willie's, I don't look, Miss Lane, I have not been partaking in alcoholic beverages in a very long time, but I've been invited to Bamboo Willie's. It's more like a Hooters, these sports bar, like sports.
It's affiliated with them, yeah.
Yeah, like I don't think, I don't, if anybody give anybody a problem with that, I know, I'm not gonna, come on now, we gotta know.
Well, we just want to make sure we
Yeah,
communicate to
yeah.
our members to make sure they understand the process.
The intent is not a package store.
Right,
Basically.
but understand that our concern is not
Yes.
necessarily you guys, but people will call in
Call, yeah, yeah. Yes.
through the customer service line and be upset, one, that the trolley wasn't moving, right? and then the operator went in here. So their perception that they give off to you, we want to make sure that you look at the full and of it and make sure that, you know, I understand their complaint, but that wasn't the purpose. So that's where we're trying to have some balance, right? Because people have the right to call in, and their perception is generally not the operator's perception.
Yeah.
Now, if we got an operator walked out with a drink, sat the drink down, and we know it's a bar, you're not gonna get a problem with us, right? But that's our intent, to be on the
They should have
same
left the
page.
drink inside when they finished.
Yeah.
Right, that's just being stupid.
Right. Well,
Okay.
So, I'm sorry.
Go
We just
ahead.
wanna make sure.
We're not trying to critique the language, we're trying to get an understanding of
We
where we are.
don't, we don't see it as any place that sells alcohol. We see it as a bar.
Okay,
That isn't a bar restaurant.
understood. We appreciate
A
it.
bar or a liquor store.
Right.
Package store.
Right. Well,
Okay.
yeah, I agree with you. on
And
that.
it's
Keyword is
liquors
primary.
Yeah.
don't-
We agree on that.
Okay.
So if we could just back up to the logo question. So the sentence, the next sentence that was added was intended to allow for, of course, the addition of the union logo.
Oh,
Does that address your
did we miss that? I'm
concern?
sorry.
We missed it.
Employees of the bargaining unit will be permitted to wear the emblem or patch of the union on the left shoulder of the uniform.
Oh, okay. I stand corrected. I missed it.
Okay,
Just want
thank
to be
you.
sure
I
that.
saw the strike through. I was so focused
We're-
on the strike
we're-
through.
We're solving things left and right.
We agree with that. Thank you. The next sentence where we go back to what we clarifying, where it says both parties shall mutually agree on the uniform supplier. We want to have it add. This is our concern. Or change, rather, I'm sorry. We want to reincorporate that language where it says uniform supplier. We don't want to tell you who the supplier is. We understand the process that the county goes through. We're not trying to do that. We want to say uniform items, where it says supplier, and then the next sentence where it says provider items. We want to meet with the company to talk about the items in the uniform, not tell you what and who should supply it. We feel like if we meet with you and we agree on the uniform, what it looks like, how it is, that will go into the RFP or whatever the process is. So we would like to actually incorporate that just with those two words being changed to items.
Okay.
And then on the next page, page 60, section 9, part-time and trolley operators, we'd like to ask that instead of $250, it's $400 for the trolley operator. And that's all of our concerns in that other uniforms.
Okay.
And then on management rights, we would just wait on a response from you guys.
Okay. Good. I think we're gonna have some TAs. In terms of wages, we kind of are, again, continuing to break out a wage adjustment that we would like to put in place immediately, and wage adjustments that have been put on the table to date, because we do not have a direction. It's still in process as to what the wage increase is going to be on October 1st, 2021, if there is one. That's still before the county commission, and they have not resolved that yet. But there is an issue that we want to take up on wages that we'd like to do immediately. And we'd like to do it by memorandum of agreement. And it's different than what we had given you in the past. So for the first 90 days of employment, full-time operators, part-time operators, full-time, part-time trolley operators are paid minimum wage, I think, right? Paid minimum wage. What is minimum wage? 8 something?
856 or something like that?
Yep.
Well,
856.
they're getting paid 865.
865.
Okay, a whopping 865. So what we want to do is have the people that are currently in those classifications, their first 90 days of employment, and everyone hired into those positions going forward receive an hourly rate of $14.74.
1470.
$14.74. This is what the memorandum of understanding on this issue would look like.
Thank you, Mike.
So the reason for the 1474 instead of the 1475 is our pay structure that we presented to the board for approval. That is step A on the pay grade that the trolley operator bus operator would fall in.
Okay.
That's where that number came from.
Okay. You understand that? That's pretty simple. And I appreciate you explaining it.
How many people are currently, would be impacted by that? I'm asking this question for you.
The first 90
Taking
days.
your, and then yours. What, how many people would be impacted by this? Going forward or? Right now, how many people in the first 90 days in those classifications?
None.
Zero.
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 All right, well, there you go. But everybody hired
After that.
from now on would be hired in at that rate. From day one.
And there's no counter on existing employees right now?
No, we, like I said, we,
Well, we understand what you said about the October coming up, right? We're concerned about the previous MOU that we've been trying to clarify and the reasons or the increases for that period of time.
right, yeah, we don't have any authorization to do anything other than the adjustments that we have already given you, which is in a wage.
And we revised the wage proposal to include the 1474.
But we would rather not wait until the collective bargaining agreement is resolved. We would not want to wait until,
So, just so I understand, I'm sorry to cut you off, Mike, you're referring to your 625 document?
Yes, I believe so.
Okay, with the rates and stuff on it, and then the MOU on the back? Okay, I just wanted to make sure I was clear on what you were talking about.
yeah. But some of these things, you know, it's taking a little time, it's gonna continue to take a little time. We would like to,
No money in the budget right now?
there's no money in the budget right now.
Sure about that?
I don't know. No,
But
I
just
don't-
asking.
I'm not sure about that, but
Interesting.
So I did revise Articles 1, 2, and 35. As I mentioned, Article 1 does not address the COPE deduction, but perhaps Article 2 will be agreeable, and we can show you the revised Article 35, which goes along with the revised memorandum.
A bit disappointing, that's all. I know you got a severe problem with maintaining employees at ECAT right now. That's pretty frustrating for you. About a third of the workforce down in operations and almost now getting close to half the workforce in maintenance.
Yeah.
Just
The
lost two
intent is
months.
to incentivize new hires.
Yeah,
That's a
new
big
hires.
problem.
New hires, we understand that.
We understand that, we
And the
appreciate that.
workforce all over the country is having a problem. But what about the people that have worked during the pandemic for you, the people that put their lives on the job every day,
For hurricanes,
with hurricanes and everything else, they're not being,
got COVID.
so, okay, we understand, what we want for the record,
Too bad the administrator wasn't in here to have that last
we
conversation.
take that,
It was a good one, right?
It was not for
not.
me, not for me.
Okay.
Everything before that was good.
I got the phone up. I'm sorry?
We had some TAs,
Good.
Well, not,
but
yeah.
not on wages.
we didn't think that the current employees are being treated fairly in the wage proposal. We understood Mr. Malamore to say we can't talk about the future, the commissioners have not made a decision on October yet, it's not here, we understand that.
Correct.
We were talking about the previous MOUs that we have been trying to resolve the issues. And we still don't have a path to straightening that out.
I understand.
And it was told to us, you do not have any money in the budget right now.
Well, just
for
to clarify,
wages.
I don't remember that being said.
I think you asked me
You asked a question.
if I was sure that there was no money in the budget, and I said, I'm not sure.
Oh, not sure, okay.
Here's one, and
Worked
two,
it out with EMS.
and
We'll
I'm
work
marking
it out
it
with
for
us.
storing. Well, it looks like we're headed towards some agreements, and we're going to get, we are working on clarification on the issue of the felonious assault bond.
Okay.
We're hoping that we can have that by tomorrow. We're probably not gonna be able to get that today.
Yeah, we understand that. So I think both sides should continue to look tomorrow to see what other articles, since we have, I mean, we'll be able to close out the majority of the articles we discussed today. And maybe some other ones that we're close to finish off tomorrow.
Okay?
And we will have our grievance process as we talked to Mr. Administrator. You wasn't here, and we're just concerned on the grievance process about two things: the length of time and the language talking about not having meetings. We think that when people meet and they have discussions, it's a lot better than just paperwork going back and forth, and that sometimes both sides can find a compromise.
Okay.
And the language you introduced to us, it said may have a meeting, doesn't force us to sit down and try to resolve the issue. So we're gonna bring back something we think is reasonable.
Okay.
So on Article 35, wages, I just want to ask this, let me try it. So this is your updated proposal, correct?
Yes.
18 cents raise for fixed bus operators, full-time operators. What is that? I think that's less than 1%, isn't it? Yeah, it is. Less than 1%. I know the process. I have to follow it up. Okay. You're passionate about my situation. I'm passionate about the employees getting a raise after living through a pandemic.
Passionate about the money too.
And some of them losing their job because of the pandemic.
Let me ask you a question about the issue that's still between us with Article 45. It says in the language that you want restored, it says rules and regulations shall not conflict with this agreement. Makes sense, right? Collective bargaining agreement. Can't make a rule that violates the agreement, on that. And further, any new rules or regulations or changes of rules and regulations will be discussed with the union 10 days prior to their respective effective dates. Then this is the sentence I have a question on. The union reserves the right to grieve the implementation of the new rule. Now, what would that grievance consist of? Would that grievance be that the new rule conflicts with the agreement? It would violate the first sentence?
So the best way that I can put it, Mike, is if it's a working condition, which we have a right to collectively bargain,
Okay.
and we can't come to some agreement, and you say, okay, I hear you, I understand your complaint, Curtis.
Right.
However, I'm gonna implement it anyway. At that point in time, we have a right to say, hey, look, it's not what we agreed to collectively, and it's a working condition that affects our membership. So that's what normal grievance processes is over policy. Right? Because every policy that any company makes is not always reasonable. And sometimes the third party has to be the one to determine the reasonableness of it.
Yeah, but, okay. So this is what I would say to that. We define a grievance as a violation of the contract.
And the contract says that we have a right to collectively bargain over working conditions, correct? That's what you recognize the union for, correct?
Yeah, but
For operators.
if we were to, if you had a term and condition of employment, it was a mandatory subject employment, and we made a unilateral change. And that was a violation of our bargaining obligation under the Public Employees Relations Act. The third party that has exclusive jurisdiction over that, in my eyes, let you get your lawyer on the phone, you can ask your lawyer, in my eyes, is PERC, not an arbitrator. Only PERC can interpret whether the bargaining obligation has been violated. That's what I think the law says, not an arbitrator. An arbitrator reads the contract and decides whether the contract was violated. PERC decides whether the statute was violated.
Right, but we may not be arguing the statute, we may be arguing that the policy doesn't allow me the right, you never gave me the right, and I don't agree for, let's just say your policy imply, forced wages on us, or healthcare benefits. I have a right to bargain over that, whether it changes or not is a whole nother story, but there's a process for it, and I have a right to grieve it. I understand what you're saying is that, PERC says that whether, PERC's decision would be whether it's grievable or not. Well,
No,
it's implicit.
PERC's decision would be whether we had a bargaining obligation. PERC would say, PERC is the body that says you didn't bargain in good faith. You made a unilateral change without going through the bargaining process. Not an arbitrator. Because an arbitrator, I mean, they might not even know Florida law.
But I said, my comments probably hit on both. Because my comments was like, the rule that is being implied is not reasonable.
Well, if the rule that's being applied violates the contract, then I can see where an arbitrator could weigh in.
So I think the problem, and maybe I'm not hearing it right, but I think I am. You're trying to get me specifically to verbiage in the contract. Well, but my rights are not just limited to verbiage in the contract. My rights are limited to working conditions. Working conditions is in the contract.
Well, any working condition that's in the contract is subject to the grievance process. If it's not in the contract, then it's not subject to the grievance process. Because the grievance process is, a grievance is a violation of the contract. It's enforcing the contract. So if you are talking about something that's extra contract, outside the contract, you would go to PERC. I think if you ask, I think it's Florida law. It might not be law, that the law in other states,
Well,
but I think it's Florida law.
I've had this conversation with Mark, and he thinks it's probably both, to be honest with you. And it depends on the actual situation or the issue where he would
Well, I just,
refer one to the other.
as we consider restoring or not restoring that section 2, we want to, that's what I'm asking about. We want to know exactly what's in your mind, so that if we agree to it, that we don't get 6 months down the road and you file a grievance over something that we think doesn't fall within the definition of grievance, but would be something that would have to be covered.
Right, and just for the sake of having good communication,
Yeah.
if that ever happened, then I would think that we would have a conversation, and you would say, Curtis, Mike, I think you guys need to involve Mark and ask Mark, and if we have to withdraw some and then go to PERC, then that would be fine. I think that our position isn't always find our number one position is always to find a solution to the problem, which means sit down and have a conversation and see about what we got.
Yeah.
That's the last resort. In the last resort, we wouldn't want to close either process, and whichever venue it's supposed to be in, that's the problem.
Well, yeah, but to be honest, if you file a grievance
because you thought we made a unilateral change without bargaining. Our response would be, the grievance should be dismissed because it's within the exclusive jurisdiction. And so we should have that understanding up front rather than fight it.
So, let me understand this. So, if we're discussing a policy and the policy has changed, one of our concerns in your literature is that, the proposal is that there's no meaning to try to resolve the issue. That, we believe that the grievance process, if nothing else, brings us to the table to try to resolve the issue.
Well, if it involves a mandatory subject of bargaining, then we have a duty to bargain. You can't unilaterally change something. If it's not a mandatory subject of bargaining, then it may require impact bargaining, but it depends on what you're talking about.
I agree, and that's why we think the grievance process or PERC process,
But that's
whichever venue it's supposed to be in is fine, but why would you close that opportunity out for us?
So I have a question, just a hypothetical scenario. So if HR brings to the board a new policy for all employees, or a rule or regulation that will impact the working conditions, that we're required to do something additional, working conditions within our department, goes to the board, they approve it, it updates the HR policy, ordinance, or what have you. Would that fall in line with what you're asking in this particular section?
We would be more concerned about the ECAT workers and how it would affect them versus the overall. And I don't think, and I'm not speaking for everybody, but I think policymakers sometimes don't think about departmental issues. They think about across the board stuff.
Well, I don't want to belabor, but I could give you a real quick example.
And I'm not an attorney, so I don't have the answers to all of them.
No.
So,
This goes on the list of questions you're asking your attorney, right? Like,
no, and
I don't
maybe
know,
tomorrow.
did we
tomorrow.
agree the last time, Mike?
Yeah, maybe tomorrow we get Mark on the phone to have a discussion with you and Christian. I don't have a problem with that because I'm not the expert.
Right. Yeah. Well, I'm going to give you an example. City of Jacksonville said they come to the conclusion to pass a new policy that says their sheriff's deputies, because that's their police department, they all have to wear body cams. This is 2 years ago. For obvious reasons, cities were adopting a practice of having people wear body cams. There's nothing in the contract on whether or not you could have body cams. The police union objected. They went and implemented it anyway. They passed the policy over the union's objection. They issued the body cameras. Those people, police union, went to PERC and said, we failed to bargain over the use of body cameras. I don't think that issue can go to an arbitrator because it's a matter of the interpretation and application of Florida law. That's just my call.
No, and I won't argue because I'm not the expert, but I will make sure we have a conversation with Mark, and if he has anything different than what you're suggesting, I will ask him to find time tomorrow while we're in bargaining and possibly have a phone conversation.
Okay.
That's all. I mean, I think every time Mark gets involved, there's some closure to issues.
Okay.
So if that has to help us, then we will go for his expertise.
Okay.
Okay. So I did write it down, so you know.
So, just to reiterate, what we included in our proposal just tracks what's in the statute.
Right, we understand.
We were asked to consider to restore section 2 out of their proposal.
Right, the way I take it is if the grievance process is not the right venue and we withdraw the grievance process verbiage, that y'all would be okay about restoring it to say PERC. That's not correct.
Ask me that one more time.
So on the paragraph that we're asking to be restored, that if we, for an example, withdrew the grievance process and incorporated PERC, then that would solidify what you're trying to say.
I think the grievance process applies if the rule or policy contradicts something in the contract. If it is not addressed by the contract and it's outside of the contract, then it goes to PERC.
Okay, so I understand. So if we modify the language to say that, then you would be okay with it.
And well, I would feel, I don't know how my team feels about adding that to the contract, but at least that's a correct statement of the law.
We'll talk about it.
Yeah.
Well, I understand. Well, we'll have a response in the morning, or if nothing else,
Good.
that we've got contact with Mark.
Okay, good. Do we have anything else?
Right now, we don't have anything else.
Who's gonna take responsibility for, doing the articles that might be TA?
Who's signing?
No, like, I know we did 1 and 2.
Well, we provided them. I don't know if you.
Yeah,
wanted to
there
sign
was
them.
also,
35, but I don't think we're gonna do that.
Yeah, well, yeah, so.
and you're gonna do,
And we're gonna TA on this one because it's front and back, so 35 is front and back, and that's, we're not gonna sign off on that. But we are willing to sign off on the way,
we'll
the way
bring,
she changes, Article 1 and Article 2.
all right, what we'll do is, we'll take responsibility for, we'll come in with the answer on 20. And you've made a couple changes to the uniform article, and we'll respond to that.
Okay, I'll bring additional copies of 1 and 2 tomorrow.
All right, good.
So, Mike, keep moving.
Yeah.
We were curious, and we'd like to have a discussion with you about what we think is a simple article, but your team in the last bargaining session removed it as a article, but we'd like to know the reasoning behind the thought process of removing seniority out of the labor agreement. And we actually thought we were right there almost to the end of having a TA on that as well. So we were kind of curious of the thought process there.
All right, why don't we take a caucus, short caucus, and we'll come back and I'll answer that question.
Okay?
Jim, cut it off on me.
Cut it off.
Look, you don't even have to do that, Kimber, we can just slide it this way.
Yeah, no, like,
Yeah, just leave it like that, you know.
I think everyone else has seen Jerome in previous negotiations, so.
the light is red now.
Okay, so we're recording.
All right, great, we're back. Thanks for that caucus. What we thought we might do, first of all, with regard to seniority, I mean, we've been kind of going around on seniority for a while now. If you want seniority in the contract, I mean, we propose language, and if that's acceptable, we put it in the contract.
You're saying you will propose, or you?
No, the language that you had previously proposed.
Yeah, I mean, we'll put that back on the table, but we just didn't think it was necessary for the contract, and it's just, we're trying to cull out issues that might hold us up, but maybe not necessary.
For us, I'm gonna say, I know you as a labor attorney already know it, but I'll say it for your team. Seniority is probably the #1 issue in any union organization. That there's a process, that for a fair process from our perspective, organizational wise. So yes, we definitely want some type of language in there that specifies.
Specifically transit unions.
Correct. Yeah.
Okay.
Okay.
Specific
We
to
also-
the unit,
We
correct.
will discuss it and bring a proposal then.
Yeah, so I just wanted to say that, I don't think, I remember yours offhand, but regardless to it, I will read over it tonight, and I will wait for, like Ms. Christian said, tomorrow, if y'all bring something different. But philosophically, that's very, very, very important to us.
Okay, good.
Can I just get clarification from Ms. Huell? Is your last proposal dated March 2nd?
I honestly don't remember.
Okay, that's the one I have.
We
So,
thought it might be helpful this time, I'm gonna step out for just a minute, I'll be right back in, but we thought it might be helpful, Mr. Kimbrough went through our wage proposal that we have on the table and how it would work.
Okay.
And so, sir, if you don't mind.
Oh, yeah, no problem. So,
Give me 1 second, let me pull it up, Mr. Kimball. I can walk through this. I got a stack of pages in front of me, I just want to make sure. Okay. We're looking at the one that y'all gave us today with Article 35, I mean, 1 and 2 attached to it, correct?
yes, sir.
Okay, I'm with you.
So I'm not even gonna get into the numbers of it all. I just wanted to make sure that it was just on record, that it was stated, number one, because I know right now the county is going to wage to scale. And then the county is going to wage to scale. Because of the previous year's MOUs that have not been addressed. Right now, our current employees that we currently have right now in our building, right now, currently, will be placed on the wage to scale, which is the, our top rate right now, and what's in front of us right now. I'll allow you to tell me what's the name of the job you see right now that's being proposed.
1984.
Is the 1984, which is technically, as I heard, 18 cent, what we currently have. And what was being given was in hopes that if we sign off today, or in our negotiation today, our wage to scale, hopefully in the near future, right now, hoping in October, the board will approve another increase or raise. Then if we can go ahead and get this done, hoping that that'll allow us to be able to get the next raise in October as well. But what's happened, and I'll have to again state that what has happened, I know the previous MOUs, and I can't go back and change that, but the previous MOUs that were presented that had the 3% increase, that now that we're going to scale, that's not being presented. And being that that's not being presented, this is what's being proposed for our current employees right now. The 1984 top rate for our bus operators.
What's the percentage wise?
Percentage rise right now currently, if you take out 1966, that is, it's about a 0.086% increase. But if approved, another wage increase is approved, that allows us to still receive. Because what I'm hoping is that we don't miss out on another opportunity to receive an increase. Because the previous MOUs from in the past, it's not in front of us right now.
It is in front of us because y'all are taking, we're going to impasse. That is going to be an impasse issue.
Okay.
A point of clarification, this was presented as a contract proposal, which would mean it wouldn't go into effect unless or until a contract was ratified. The memorandum of agreement that was presented to address trainee pay. So there's two separate things.
I understand.
Wanted to clarify.
And we also understand that, that you've imposed impasse. And for us, wages, the previous wages that was on the table is what we're going to take the impasse.
Yes,
If it's off the table, as you say. So
yes, sir.
I think we understand. I don't think we agree on or like it. A better word is like. I don't think we like it. But
I just wanted to make sure that it was clear, clear understanding, you know, like, where we are in regards to wages right now, right?
Well, I heard the commissioner loud and clear this morning, told me I should have made sure that we signed it and got it, but that the MOU took away some pertinent benefits to us under the wage scale that we've lived under for 75 years, and every single one that I'm aware of, I don't know everything, so I'm gonna say that I'm aware of, every ATU contract, city or not city, has a wage progression.
Even right here in the state board.
Entrenched. So I don't understand, maybe the commissioner didn't understand. For us, it's about one sentence, which took away a bunch of things that we previously have lived for, even under the county. It's not that we didn't want it. When you put stuff in it that's different than what we've had, we have to do our jobs. My job is to maintain a level of benefits for the transit workers. That wasn't a minor situation. There's always a compromise in things. That wasn't a compromise. I'm doing away with it for a 3% increase. Sometimes you have to live with your position. And my grandmother told me years ago, if you stand for nothing, you'll get nothing. I'd rather stand for something.
I understand. If I can.
No, you administrator.
Well, I don't want to interrupt. I would like to think that we've made, and what we've got here does address recruitment and hopefully retention on the trainee and the lower end. I feel like that's a pretty significant adjustment to help address recruitment and retaining. I understand that it's, the proposal itself is probably not perfect. I understand that. But I hope that we can keep knocking this back and forth so we can come to some sort of resolution. But I do think we've made a significant give or proposal that addresses the lower end, which is where we're having trouble with all across the county. If you look at your higher ranged employees that have been here a while, that's usually not our problem to retain. It's our lower end folks that we're having a problem recruiting and a problem retaining. So that's was some of our thought process in those line items.
So since I'm doing both the county workers and the transit workers, I fully understand it, and yes, you're right, you have made strides, big strides for both. And that's not our #1 issue, but I don't represent future employees yet.
No, I understand.
I represent the workers, the men and women, both county and transit, who worked through a horrific pandemic.
Sure.
Who are not being offered anything for that service period of time. That's my #1 goal. No disrespect to this at all. Your retention problem has not just happened overnight. I've done some homework and research on it. The last time the county had done something like this, it came out of a wage study many years ago. The transit workers, because of it was contracted out to a private sector, have maintained normal wages increases, and probably have done better off understanding that. But that, once again, that was a decision by the county. And now we're at a junction where it's not about feeling, it's about business. There's a group of workers here that are not being identified and not being appreciated from our perspective because of something that the county wants, which is to do away for the transit workers with a wage progression. And in doing that, I'm gonna be honest, from my perspective, it's a bully tactic. If you don't do this, you're not gonna get this. Well, if you're sincere to your employees, give them the 3% wage and let's hammer out the issue of the wage progression. That's all we've been saying from day one. But you're not gonna value your employees because I'm doing my job? No, and I'm not saying you, I'm saying the county, that's the position, that's what the message is across the table. The commissioner said it to me today, sign it and you can have your raise, or you could have had your raise. Well, that's like me saying, okay, I'm gonna sign off on this and then I'm gonna stand in front of the Mack train and come on and hit me. That 3% meant nothing. I'm not gonna sell my soul to get a 3% increase. I've done the work, I deserve it. I should get it, because everybody in the county got it.
Harris, I certainly understand your point of view. And I
So
think-
we're not against, I just want you to know, Commissioner, I'm sorry for cutting you off. We're not against this. And I said, Commissioner, I'm administrator. We're not against this. We're just very much believe it needs to be a package for them. And the 3%, that the employees deserve that, if nothing else. And we believe that the money is still there. The money wasn't spent. It's still in the accounts. We didn't even come back and say, hey, look, let's fight out getting all this retro pay and doing all of that. We said, give them what they deserve.
Sure.
And if I could add one thing, just
Sure.
Wes, you weren't here before, but through all these negotiations.
Well, he was at all the meetings.
Well, for the operational unit, but not for this one. I don't think you were at all ours. I have not heard through this entire process, the one question that catches my attention the most, which is, you know we have a wage progression for the transit workers. If that is your issue, and that is your concern on your side of the table, tell us why, and tell us what is the problem on your side. Not once have I heard an explanation of what is the problem with the wage progression that is in place. Not once, I've not heard it.
They've said it to us because we want to do it across the board countywide. That's what they said.
And then the second.
That's not to me, that's the bully tactic, right? Because this is a different department. This department doesn't work like county workers. They don't come in at 9 o'clock in the morning and leave at 5 o'clock and the county shuts down. This operation is totally different. And it's very much like police and fire. Don't get me wrong. They have crazy hours.
Work weekends.
Work weeks and stuff like that. So we understand. But the county also had 75 years of contracting this work out. And they was apprised of everything the private sector contractor was doing.
And then, and one other thing is,
That's from my perspective.
I don't know that for sure.
That's my perspective.
I don't know how you contract and not know what's in the labor agreement. But the other thing is, you made a comment earlier about retaining existing employees. I'm gonna tell you, I disagree a little bit with what you said there, sir. Because I'm watching people leave at ECAP that have service under their belt. And they're leaving for various reasons. One of them is because they haven't been compensated for their work especially during this pandemic and hurricanes for the last couple of years.
I understand that. When I said that statement, made that statement, I mean, by and large, if I look through corrections, if I look through public works, if I look through parks and recs, if I look through Pensacola Beach Public Works and a few other areas, even at roads, my problem is not losing operator 3s and 4s, supervisors. You may lose one every now and then.
Right.
But by and large, that's not an issue.
It's the incoming.
It's the incoming folks we require a commercial driver's license. And if you don't go to the first quartile, what's the incoming pay? $12.49 an hour. Well, what commercial driver's license holder with any skill level
It's gonna take that.
is gonna take $12.49 an hour when they can go to almost any contractor or any company in town and make significantly more?
So there's a difference, Mr. Administrator. Transit folks love people. They love providing public service, whether it's the paratransit side, whether it's the fixed route side. We don't always do our jobs for money. And there's no other place in this county, because if it was, they'd probably be some jumping ship if we had another place to go. Like Tampa, where you got, right up the road, you got another transit provider. So the demographics are different, and if they had other areas to go to, I'm sure a lot of the senior people would need to go there too.
Well, and I'll just speak for myself. I mean, just my own experience. When I came into the county at the ripe old age of 21, I wanted my weekends off, insurance every time. That's why I came to work with this Camden County. I made $5.07 an hour. Thought I hit the jackpot. Really did. And through the years, once you make a couple of steps up, for me, just me personally, once you get 7 to 8 years in, then you start looking around, well, maybe I'm going to try my hand at something else. My benefits package is looking pretty good. I've got this many years into FRS. I've got, my weekends off, my nights off. Do I really want to make this move? Do I really want to jump the ship since I'm so invested? And for me, the answer was no. And I see that still in some of our employees out there. And I'll speak to Rose because that's where my most experience is. I still see that thought mentality through most of your more senior people. I say 7 to 8 years with the benefits package that we offer. And out there, you're working 14-hour days. Now, at Pensacola Beach, it's 365 days a year. You don't get holidays off.
Right.
4th of July weekend, Memorial Day weekend, it's all hands on deck. So it's just been my experience that my personal experience when I was at that point in my career is kind of the same that I see in some of the more tenured folks. But what I've not seen a few years ago, we would have had folks lined up out the gate to hire on to be an equipment operator too with the county because of the 14-hour days, because of the benefit, because of the insurance. You can't do it, not today. Now that might change as things shift back a little more normal, then that might swing back the other way a little bit. But as it exists right now, for me, it's recruitment and retainment. And I do understand the wage progression. And I'm not going to sit here and tell you that I necessarily think it's a bad thing. I'm not going to say that. I think it needs to be up front, transparent, that commissioners and whomever know going forward, hey, this is what we have, and why don't we have this in the rest of the county? And I think that was some of the question. Well, why are we treating them differently than what we're treating the rest of our employees, even the ones that are covered by bargaining units? So, yeah, there was some effort to kind of level things out a little bit. There was. But also, in the wage progression, I'm not trying to put words in your mouth, but I think I remember you saying that, hey, you're not looking out just for the existing employees, but future employees as well through the wage progression.
No, that is
think
true.
about
I
it.
did say that.
So, just my experience, as honest with you as I can be, if the board offers you 3% or offers me 3%, I'm going to accept it.
Well,
Now I could continue to work, like you said a minute ago. We can continue to work for what we're trying to achieve. But just in my career, I don't turn the money down. I'm going to accept it.
So I
This
want
is
to
a good
say
conversation. I'd like to continue
So
this stuff.
I want to say a couple of things, and I appreciate your honesty more than anything. One, that we wasn't given that option on this side. It was a package deal or no deal.
Sure.
We would have very much took the money from day one and continued to work on the other issues. We asked for that. We asked for a modification of the MOU as well, so I don't want to offend anybody here. But we very much would have loved to separate it as well and made sure that the workforce got it. I personally have made a similar decision as yourself in transit. When I came on, I'm an electrician. I work for Marvin, 27-year guy right now. Came on when I was 24 years old. And I made the same decision you did. I want to work for this company because this, and that. However, The transit workers here don't have that. The senior employees that just came over with you guys, they're not at 7 years, 8 years of FRS. They don't have FRS. They got it now.
Sure.
If they're over 50, it really makes, it's not gonna make a significant impact on them. We've done this study, where we try to do the transition. So for those employees, they'll never see a true pension. They've worked for the county technically for 20, 30, 40, 50 years. We have some of them that left, Willie Carter and others, that worked here 40 plus years. There's no retirement for them. So their decision-making is a little different than mine and yours, right? Because they, in retirement is it. So yeah, while they, vacation, sick time, other things are still in the benefit package. The work schedule at 50, 60 years old, getting up at 3 o'clock in the morning to be to work at 4 o'clock, pull out of service a bus and stuff, that wears and tears on them. So it's not a normal environment. And the most critical thing is preparing for your life afterwards. The reason why they work 30 and 40 years in this county, I don't know many that do it unless they just, some operators do it. But I don't know many. They do it because they have to. Sure. Because they don't have the same autonomy that you guys had when y'all said, okay, or myself, I'm gonna stay here. And at 20 years, I'm 52 years old right now. I just put in my retirement papers. At 52 years old, 27 years of service, and I take no penalties.
You did good.
Right, but they didn't have that opportunity.
I understand.
So for me to sit here and represent them, I'm passionate about how it looks for them in the future. Because we all know in this country, if the market crashes on your 401k, you eat cat food.
True enough.
So while they serve the public for 30 and 40 years, there's nothing on the back end for them. Now we're talking about a group of workers. So yeah, that 3%, we would have took it around. Just so you know, Mr. Administrator. And if it's packaged to that today, I heard him loud and clear, but if it's put back on the table separately, we would still do that. The impasse issue for us was keeping the wage progression because people move up, and as you get experience, you're rewarded in our section. And it also helps the company because you're not paying me that top wage when I have not been on the job for that long. So it's about a progression of professionalism, right? And it's philosophically, that's what we live with. And I work for a public agency too. Marty's Quizide, but ultimately, the board of directors and the state legislators run the authority.
Sure.
So I understand. And I appreciate your candidness because we haven't had these kind of conversations. But when you talk about apples and apples, oranges and oranges, we understand that we were going to make some changes coming over to the county. And we're okay with it. It's just that sometimes, just like we had a discussion on seniority, when you talk about the core of our organization, that's when we have to say, look, we can't be stripped by our core stuff. Seniority, wages, retirement, those are just core things in transit that we try to provide to our membership.
Sure.
So, we are planning to be the villains, we're not villains. We're actually doing what we have to do, because guess what? He's a bus driver, I'm a mechanic. He's a bus driver, he's a mechanic, she's a bus driver, he's a bus driver, right? So, we're just human beings. We're not experts, we're not attorneys, we just wanna, I don't even wanna use the word fight. We just wanna protect.
I understand.
And if I could add just a couple things. First of all, I'm a bus operator.
Oh. Some say operators, some say drivers, some say.
It's a title we've enjoyed all our career. I'm a professional bus operator.
I do.
That had no accidents in his entire career. I get and I appreciate the conversation here because I feel like this is a conversation where I'm hoping we just continue to go forward with this because we need to understand each other. Having to represent the operational unit versus the transit union, unit, the operational unit, I've been around a long time. I remember what their concerns. Mike Mattamore sat in negotiations 20 years ago and remembers that group of workers which worked under your supervision or that department. They had their issues back then when it came to wages. They were complaining about the merit system and that, you know, they didn't like the merit system and they thought it was unfair. And they would talk about, I can remember the guys coming to me and saying, you know, they budgeted 5% or 3%. They budgeted 3%, but if they could give up to 5%, but they budgeted 3% on an increase. But if they give this guy 5%, somebody's got to be offsetted to get reduction down to 1%.
I remember that.
You remember those arguments, right? And so with the operational unit, I've watched them go through the system. Their vision of a wage increase is different than transit workers in my eyes, in some ways. Like right now, what do I hear from you, the operational side? I know what you said about, from our perspective, look, there's a lot of people excited about bringing that wages up because they're under that wage.
Absolutely.
Right? They're far under. And I think and I've done the numbers, and I've seen it will be a huge lifestyle change when that number's brought up. Now, do I think it's compression? Yes. But,
And we already agreed to it.
and we already agreed to it over a year ago. But I have to look at the rest of that bargaining unit and say, that are the senior folks, because they're gonna turn and go, you want me to vote on this? Remember, we're in the public sector. Everybody gets to vote on the contract, correct, Mike?
Yep.
And they're gonna come forward and they're gonna say, how am I supposed to vote on this? I'm not getting anything out of this, right? So, but on the transit side, not one person is affected by your increase that you proposed today, and it was said earlier, not one person would be affected other than people walking in the door, which you're right, I do support. I support the existing employees, and I support the future employees, because that could be my son, that could be my daughter. I am 100% behind that statement. But the difference is, in the proposal to the other unit, some people are getting huge raises immediately. And we've known this for a year.
Sure.
And they deserve it.
Absolutely.
And it will recruit people in for equipment operator twos where you need the most, correct, in that department. It will recruit, I think you'll get people immediately saying, okay, now we're starting to get to where with my CDL, I'm being recognized, right? Just like this one here recognizes the CDL. But again, it doesn't impact anyone existing. What they live off of is that wage progression, and that wage progression is important to them. They understand that when I hit year 2, when I hit year 3, when I'm gonna get to this level. Under the proposal that you guys gave before, it doesn't tell me what happens going forward. So when she gets a raise and she's making $20-25 an hour, and that other person comes in and they never can catch up to her, right? And they're only a year or 2 behind her. How do we explain that? That's why I always wanted to know from your side, what is the issue with the wage progression? What makes you guys feel that that is a problematic? And you mentioned the new system, which we are not educated on either as well. And understand, would like to know how does that benefit
I'll be
workers?
honest with you, I don't know that I'm all spin on either.
Yeah.
Perfectly frank with you.
Right.
And I'll repeat it again, like I said a minute ago, I'm personally not necessarily anti-wage progression.
Right.
I just think that we need to make sure that the board understands what's in place or how we're moving.
Yeah.
And
If you think it's too short for wage progression, tell us.
Well,
That's
we
your
haven't
issue.
eliminated the wage progression table. That's in the proposal.
I get that.
So I guess to say all that to say this, I don't think we are going, nope, we're done. Not saying that at all. I want to continue to work. I want to continue to have these conversations. I want to continue to be upfront. I want to continue to be, I'll be honest with you when I have to be, when I need to be honest, I will. But I'm committed to working through this contract. And maybe there's things in it that we're just not going to come to agreement on, and it'll be what it'll be. But I will work to come to an agreement on things. And like you, and I hear you say it all the time, it's a compromise sometimes. Not both sides don't always get what they want.
Correct.
I understand that. And I think, listen, I think I can stand up to the task. I hope I can. Or maybe I can get as close. I don't know. But I've got confidence in these folks right here around me, and Tanya Rodriguez and Wesley, and certainly him. He's smarter than I am, for sure. But you know, what I don't want y'all to walk away with is, hey, they're just closed off. They don't want to talk. They don't want to bargain. They're just going to bully us around. That's not my mentality. That's not how I do business. So we're going to walk. We're going to work, and we're going to come to agreement on everything that we can come to agreement on. Like I said, if we can't come to agreement on things, then we just can't come to agreement on things.
Yeah, and trust me, I've been told no before, right? And so the problem, and I think Mike said it best, the problem is when you tell me no, if I understand it, then it's easier to understand where we're apart.
Sure.
And it's my goal to either accept it or let it draw out to a process that I don't have to take it off the table, but maybe I can find a compromise when you tell me what the issue is. If you don't tell me the issue, except I want to do it because the county's doing it, then I can't justify in my mind how that works, right? Now, there's some things that are going to happen across the board, no doubt. Right? Just coming over, like I said, we already knew some things were going to change, especially policy-wise. And look, I do this every day. This is all I do. I'm actually fortunate. All my assignments have contract me. It's 5 days a week. That's all I do. And with that being said, I've seen some really tough situations end up really some really good situations. The only time I've seen it is when you sit out and talk. Because there's a perception on both sides. And when you deal with the perception, you get bogged down. When you deal about talking about the issues and leaving the perception at the outside of the door, you usually find a way to work through it. And you usually find out that, and I'm sure, because Mike's done it since I've been working with him, when you hear the other side about the things that are important, those are the things you kind of try to find compromise on. Because then the other side feels like you're listening to them. It's going to make a difference for their organization. The only problem here is we're just an organization of people. You have the power to do what's best for the county and the workers. But these are your workers.
Absolutely.
So we feel like if the employer is listening, then we can resolve issues. We'll always tell you what our issues are and why. That's our goal.
I will do the same.
Our goal is to educate you on why we feel the way we feel and why we're standing firm on issues and why we're not. And negotiations is sometimes, I'm just going to hold firm on this. Mike knows. If they make some movement over here. And usually when you get down to the wire, people change their positions, you get the contract. I can live with that. I've been holding out on that, you know. And I thought, and I'm not going backwards, I thought we were there the first time. The only critique that I've had since I've been working with the county has been, and I appreciate today and tomorrow, is that we only meet a half a day. You can't get things done and you're parking it for a month or two. The more you meet, the more you talk, the more you can resolve issues. The more it's exciting. I'm not gonna lie, I've been so bored with this negotiation sometimes. It is what it is, right? So today has been a breath of fresh air. Mike come in and say, I looked over these things, I think we can move on these things. That's what the goal is. we're not far off on a lot of other articles. Right? And some of them we agreed to already, not gonna beat us up. But if we can agree to it one time, that tells me we can agree to something the second time.
Okay.
And it might not be the same exact, and I know we gave you the same exact language, but it might not be the same exact, but it should be able to be pretty close. If we can live with it then, tell us why you couldn't live with what you could live with. We have to decide if we can live with it.
And we'll continue to work.
So, I appreciate you listening to my long speeches. I know my long
Likewise.
speeches.
And I'll make one last short thing, In previous negotiations, we asked to address some other articles that we felt were more operational. And, you know, I felt from the last session that, and Mike, my memory serves that Mike thought it was okay, but I don't know, of course he works for you, so he has to go with the team, I'm sure. But my intent was, on our side, was to work it out with the management team who deals with it on a daily basis. And I felt they're obviously would work with us, we could talk it out like we're doing right now. And we would have been able to walk in today and say 3 or 4 articles, here they are, just like, and boom, they would have been all, we would have had not 3 or 4 TAs today, we could have had 10 TAs, or maybe 8 more TAs. It was, you know, I don't know how much you want to listen to, for instance, extra work or assignment of runs. Maybe you do want to listen to it and you want to hear how it works out in the discussion. But that's the kind of thing that it takes communication back and forth to understand why you kind of twisted or changed the proposal a way that we've never seen it before, right? We have to understand that. And once we understand it, but it also allows, for instance, Ms. Ellis and Mr. Kimbrough to tell us, okay, this is the way we used to do it, but this is why we have to go another way. That allows us to go back, kind of evaluate that, think about it. I mean, they both have expressed to me that, as an example, history showed that we select buses, right? A simple thing, we choose buses based on seniority, right? Might not be able to do that anymore because we've now learned that the private sector was not tracking the mileage correctly. They were just allowing that to happen, and that's caused a problem for you to get new equipment in the future. Is that correct? And what have I told him? We can work that out. I'm gonna have to go back to my membership and explain this to them and get cussed out. Trust me, I'm gonna get cussed out. Seriously, they will cuss me out. They will be like, you gotta be kidding me. You mean a rookie could end up in a new bus and I'm gonna be stuck in an old bus, right? You know, a 7-year-old bus versus them driving something that's a 2017, a new bus from Sarasota. But I have to educate. When I can go back and educate them and tell them the facts and say, look, if we want replacement buses and then to have a system to have that in place so we can continuously not be in the predicament we're in now, I can educate them and then they can feel comfortable about it.
So everybody can have a decent bus.
Sure.
Not bad versus old versus new, but decent all the way for the whole fleet. That makes sense.
So while we're having this discussion and being honest, I want to broach a subject that, being honest with you, I don't like it. I don't like to see folks walk up to the podium and speak very derogatory about Ms. Ellis or about Ms. Hewell or about any other member of the staff. I don't think it's beneficial. I don't feel like it is conducive to making progress. I think it's a hindrance to our progress. I would hope as we move forward that we can treat and talk with each other and about each other respectfully and calm. I'm not saying you gotta agree with them. I'm not saying that at all. But I don't, being as honest as I can be with you, I'm just not.
I appreciate it.
I'm just not about that.
I'm usually not about it, but here's what I would tell you. I've been working in this county since 2017. I started out these negotiations in this very room. I've said it frequently, and I bite my tongue in this room or wherever we've been. The tone from this young lady, she even called international one time. There's a little history here, right? And I just been taking it. I speak up about the things I don't like. I've said it in open meetings. I think you've probably been in a few with the county where I've said, hey, look, stop cutting me off, stop doing this. But I said today, I was sincere about it. I'm not willing to bite my tongue on it. And I haven't been to the county and said that before to the commissioners. I had a conversation with you earlier this week. I respected it. I didn't agree with it, but I respected it.
You did?
I should have a right to speak my piece. Hold on, let me finish. And so, what I said about this young lady has been what I've been doing. All the way up until her telling, in this room, I asked Mr. Malamone, all communications to come through me. After that comment, this young lady used to go to him, straight to him. Not even copying me on some of the correspondence, right? Early on, right? Okay, there you go. Right. Every time something would happen, it would be, you know, those type of things. You know, always with, every time I spoke, I felt that it was always an issue. She always had to correct me. She always had to do this. Never respected what I said or done, right? That's my truth, right? Whether somebody agrees with it or not, that's just like me sexually harassing somebody. They don't have to, I don't have to feel like I sexually harassed them, but if they feel like it, I have to respect it. I don't feel like it. So I'm being very honest about that, okay?
Yes, sir.
When it came to me speaking up about Ms. Ellis, I spoke to Ms. Ellis about how I feel about the termination of Mr. Lowry. I didn't put all the dirty laundry out there in this morning's meeting, but what I did say, I'm very firm on. He got disciplined wrongfully. They're not getting disciplined for the actions and the unprofessionalism that they go through, that they do. I didn't ask you to discipline them. I said to you that, and I mean it, if the county policies apply to him, it should apply to them.
They do.
Well, I'm telling you, I felt disrespected. I'm telling you, I don't believe that all the policies apply to your management staff. And I have that right, and I spoke about it. So, I hear you loud and clear about moving forward, but sometimes you move forward, you gotta move forward with the truth being out there. For me today, I'm telling you, I don't think it's right. What's happening to, and I don't wanna use our bargaining session, just,
No.
but I never raised my voice earlier. I never disrespected you or any commissioner. And I said my truth. When the county clerk spoke up, I've been coming to these meetings for a very long time. The county chairman, commissioner chairman, did not give me the same opportunity that other people have been afforded when somebody speaks out against what they say. I stood there and I spoke my truth.
I understand.
I didn't make a big deal out of it. Just call the police up. That's his right. I don't feel like I got treated as equally as everybody else today. Because the first thing that they did was call the police. Other people get more time, or at least they listen to what the direction that they're going, and then they make a decision. I didn't have that opportunity. So I felt violated by the chairman this morning too.
I understand.
Getting escorted by the police for doing what I feel is right, I don't care. I don't care if they would have arrested me. As long as I know I was doing something right. And speaking my truth, they have a right to speak their truth. And I wouldn't be offended one bit. Not one bit.
I understand.
So, in negotiations today and moving forward, I told my team during the break, I don't see that behavior today. Since we've been in this room today, I haven't felt that, what I've been feeling for a whole 2+3 years or whatever from this young lady not one time. But guess what? I felt the tension that people came in here and didn't speak and have the common courtesy to say hello to everybody. Miss Tanya did, and I appreciate it. Right? Because she didn't take it personal, because it's not personal. It's not personal about what Mr. Ellis. It's about the business stuff, right? And we sit across the table and we have a job to do. And I respect him there. But guess what? Your whole staff didn't come in here. Only 2-3 people that spoke with these three right here. Them, oh, I'm sorry, the young ladies over here. But, so there's still tension, right? Because I spoke my truth. But guess what? I should have been greeted just like everybody else. Good afternoon, how are you? You don't have to personally like what I said or did. I don't personally like how I was treated. And I will tell you, under your administration and today, I've seen some major changes, right? And I'm not here to beat Ms. Gilly up, but I see the difference now. Before, I just know what was happening.
I'm with you.
So that's my truth. And I look to move forward, and I think I conduct myself in a very professional manner. I really do.
Well, I can assure you what you see from us will be professional. I don't think there was any slight. If I didn't say hey to you, it wasn't on purpose. I was running about halfway late when I come in the door.
I wasn't referring to you.
So, but however, it's like you felt like you needed to say some things this morning. I felt like I needed to say it while we were having a good conversation back and forth, good communication. I felt like I needed to say that, and I hope as we move forward,
It's well received.
then we'll
I'm not offended.
we will be able to move forward and negotiate in good faith and accomplish something hopefully.
Okay. All right. Yep. I appreciate it.
Okay. We've addressed, we've had a conversation on wages. We have addressed the question of seniority. Is there anything else?
No, like we said, we'll try to go back this evening and find out the other things that we believe we're close on and try to have some good dialogue tomorrow and close out.
Okay.
We believe that there's a couple more.
Or at least start hashing out a couple articles that I think we can talk through.
Right.
Definitely think so.
Right, and you know, Mr. Kimbrough talked today about wages. On some of those operational issues, there, Ms. Ellis and Mr. Kimbrough's here. You can have that conversation with them tomorrow.
That's fine.
Carve out an hour and have that conversation. We would just like to be a participant. We'd like to hear what you're talking about, so we understand what's going on. We might have to explain it someday, like you're talking about explaining it to your people. We might have to explain it to our people. So they look to the administrator, they look to the school, they look to the chief negotiator to say, why did you sign this? What does this mean? Why were these changes made? So we would appreciate the benefit of being a part of that conversation, but you can have that conversation.
So I think we
We
should.
need to meet more then.
I think
More
we-
often.
I think I'd like to make a recommendation that we email you. We'll have a conversation. We'll email you to have a conversation on tomorrow on one of the issues that we think that we would like to talk our way through tomorrow.
Okay.
That's operation. In this way, they'll have an opportunity to look over, get a feel, and understand what's going to be discussed.
Yeah, I think that's a good idea. If we do in advance the topic area, and
We should be able to do that by 5, 6 o'clock.
Okay.
So everybody it's not hard for us to find out what we think we can.
Well, I'm ready. I know which ones I want to talk about.
Right. So, I mean, we're ready, so we'll do that tonight. Just take them one at a time and just go through them.
I'll tell you, we'll start with Article 31.
Mike, we had talked.
I know,
Get
but
stuck into it.
I want to keep that article straight.
he's off the chain.
Yeah.
He's off the chain.
Yeah.
I'm off the chain. He was,
Yeah, because right away Jim looked and said, hey, I got some maintenance issues.
I was about to call out a maintenance article too, because we do have some concerns about some maintenance, but we could do that off this negotiation.
But on the record, I do appreciate the tone of today, and I thank you.
Thank you.
Very good. All right,
So we're gonna stick around and have a quick discussion so we can get that. and-
Can we hold them up for just a second to talk about something existing? Could you give us a couple minutes, Ms. Ellis?
That's up to
We
them.
can, bro, it's up to you, but it's pending issues that we just wanted to mention to you, so maybe tomorrow we can address it, but I just want to mention it to you that.
but they belong.
I don't want them to blow up.
Are
That's
they
all.
negotiations? Or-
No, they're not negotiating, they're pending current existing issues facing maintenance.
Is it gonna be long, because maybe?
Well, I mean, I can just verbally say it right now.
Yeah, go ahead, say it.
So, there was a choose up done, and I think we need to look at that maintenance choose up and have a discussion. And I kind of saw the reasoning why Mr. Zambrano is probably doing what he's doing, but without having a discussion beforehand. Because I think it's because of the loss of workers there. You lost 2 master techs the last couple of weeks. And I believe taking away 410s from the senior most employee isn't something that's gonna be permanent, I hope. Is not gonna be permanent, but
Mr. Lowry, sorry, I'm sorry. Should we stop recording
Yeah, I
if
think we
it's
can.
not
Oh, yeah.
union participants?
yeah, this is not
Okay,
bargaining.
sorry.
Yes.
Thank you.